Hi, everyone. We're going to give everybody a second to trickle in, and then we will get started. I can get us started off here just with some basic updates and some housekeeping. So to start off, this webinar is being recorded, and everybody who is registered will receive a copy of the recording at the email that they registered for this webinar with. And then secondly, we are going to have a Q&A session at the end. So if you have any questions for Heidi, if you could put them in the Q&A section at the bottom, as opposed to the chat section, that way we're able to find them and get them answered for you a little more easily so they don't get lost in the chat. And then before we get started, I wanted to just promote that we have our 63rd Annual International Conference coming up in February. It has over 100 educational sessions over the course of 3 days, focused on similar topics to these. If you're interested at all in what's going on in law today, in advocacy, we have several advocacy sessions. So we encourage you to check it out. I will put a link in the chat so you can learn more about LDACon. And then Monica, I'm going to turn it over to you if you want to introduce Heidi.
Okay, thank you, Lauren. Hello, everyone. I'm Monica McHale Small, and I am the Director of Education at LDA. And I'm very honored to welcome back my friend, colleague, and special education attorney extraordinaire, Heidi Goldsmith. Heidi is part of LDA's Professional Advisory Board, and some of you may have joined in on some of her webinars in the past. So she's going to provide us an update as much as she can update on what's going on in the world of special education and education law. So Heidi, take it over.
Perfect. Okay, so the first thing, obviously, that we've had some longstanding concerns about was the case out of several different states that sued the Department of Education under the Biden administration about Section 504. And just to give a little bit of history in case there's, newer people on the line, the case really stemmed from the proposed new 504 regulations. And just so we're on the same page, there's two kind of 504 regulations. There's the special education ones, and then there's the ones that were for the HSA, and those were published. And so there was a lawsuit because there was some issues in the preamble relating to gender identity. And so the state sued to say 504 should not cover gender identity. The difficulty and the problematic situation that caused the disability community to kind of get really worried was one of the wherefores, which is in terms of a law, when you file a lawsuit at the very end, you have like a wherefore, and then you ask for what you want to happen. And one of them was, I forget if it was point three or point four, finding Section 504 unconstitutional. Well, obviously, if Section 504 was found unconstitutional, that would impact all people's rights, whether it be special education, housing, anything that 504 touched. So there was a large, very much advocacy groups and parents at very much different state levels pushed back on that. And at the time, the AGs had different varying responses. And you can go see them on, they actually published videos and they would say either, no, it doesn't say that, that's not what we're doing. Well, that's not what the intent is, or we're not pursuing that aspect of it. But they were all made very clear that they were not looking to impede children's rights with disabilities. Obviously, there was a new administration change, there was a new executive order issued, and what has sent that lawsuit now is into the kind of this status of hanging out there where there is not conclusion, but there isn't necessarily an active case going on. And so what the court has, so basically the state said, whoa, we have this new EO. We don't know what the Department of Ed's going to do. Maybe we don't need this lawsuit after all. And so the court has sent it into this kind of status update, hanging out situation. So there's been a status update. And the last time I spoke about it, which was the last status update we had, the last time I spoke was in July. And basically at that point in time, the Department of Ed had some responses, and we were really looking forward to finding out at the end of October kind of what the status was going to be. Well, then the government shutdown happened. So the status update did occur in October of 2025, but the status update basically said the Department of Ed, due to the shutdowns, have not really had a chance to really look at things. And at this point in time, the DOJ, due to the shutdowns, can only work on emergency situations. So we really can't provide a comprehensive status update. So it still is malingering out there. The next status update, I believe, is it's January 2025 early. I think it's like January 9th or so. And so that is where we are at right now. Hopefully, we get a kind of a conclusion so we can all take a complete deep sigh of relief over the fact that that court case will be dismissed and we will be able to move on from it. But at this point in time, we are still kind of in a situation where we still have to monitor it because of the fact that if it goes forward in some capacity, as much as the AGs and those the attorney generals of the different states have said they're not looking for that to occur, a court can still find something unconstitutional, even if that is not something that is being sought for under the court case actively. So, again, not a current crisis, but something, again, to keep our eye on. I don't recall if I talked about it last time, but it is kind of like very rarely in education do we get Supreme Court decisions in special education. So when we do, us lawyers get very excited about it and we love to talk about it. So I do want to talk a little bit about the recent Supreme Court case we had, which is Osseo versus, I think it's AGT. And in it involved a student in Minnesota, and I'm very familiar with Osseo School District because it was a neighboring school district to my school district I grew up in. And what had happened in that case is there was a student with a disability who wasn't able to attend school. And while the district, I think a previous district had done a lot, or this district had previously done more to ensure that that child was receiving an appropriate level of education, Osseo School District said, no, we're just going to do shortened days. We're not going to do to the level of services as before. And the parents then sued in federal court for damages related to that lack of education. And there is a split in the circuits. And I'll just take a step back because sometimes I, assume knowledge on behalf of listeners that I shouldn't. But in terms of the way our government system works, in terms of the legal system, each group, there's groups of states, and they may not even be next to each other. For example, I'm in the Third Circuit. And while we do have neighboring Pennsylvania, Delaware, New Jersey, we also have the Virgin Islands is part of our circuit. So theoretically, I could practice down in the Virgin Islands as a federal court attorney down there because again, they're part of our circuit. So we're in a situation where there's different circuits, there's in the country. Each circuit will hear cases and make decisions. And that's part of sometimes when parents come to me, they'll go, look, I found this court case out of, Oklahoma or California, and it says, or you could pursue. And I'll say, well, that's not the law here. And this is kind of the crux of the case. And you go, well, how can that be? It's a federal court statute. Well, the federal courts interpreted. And if there becomes a situation where there is a real conflict in the circuits, that's what the Supreme Court is for, is to kind of set the ideal situation of what the law on the land is for the entire country. So this court case involved the legal standard that you had to prove your case to be able to seek damages and win damages. And that's important. And let me kind of, again, take a little bit of a pathway down the legal realm. When you go to different court cases, and I'm sure if you've watched any type of court case, you'll hear, beyond a reasonable doubt. That's a legal standard. Deliberate indifference is a different legal standard. Preponderance of evidence is a different legal standard. There's all these different legal standards out here. And in education law for damages, there was kind of two separate legal standards depending on the circuit. in the circuit where we're at, Third Circuit where I'm at, it was deliberate indifference. And that is a situation where if I pursued damages under 504, I would have to prove that the district knew about the discrimination, that it had the power to fix it, and it failed to act. And let me kind of give you an example of that. For example, let's say it was a situation that a child was and I'll give you a real life example I had. So I had a student who was sexually assaulted on a bus by, it was a student on student situation. And in that case, we were able to survive dismissal because we had evidence that the district knew of the child who perpetuated the sexual assault on my client had a history of inappropriate touching. And so the district knew that this could occur. They had the power to create a situation where they kept my client away from that student and not placing them directly next to them on a bus, and it failed to do so. So we were able to survive dismissal because we were able to prove that facts. Well, there was a different, higher legal standard in Minnesota where it was called bad faith or gross misjudgment. And to prove bad faith or gross misjudgment, you have to prove that the school district acted on a hostility, ill will, malice, that it intentionally tried to harm or the student. Like they purposely knew and put the student next to the student. That somehow we have to show that the district wanted to violate the students. Like they hated the parents, and so they were trying to get the kids injured. Or gross misjudgment, which was so outside the professional norms. It had to be more than negligence or more than poor just judgment. Like it had to be so shocking and extreme or egregious. And so that is, and I'm sure you can imagine, really hard to prove when it comes to school district cases because bluntly, for the most part, people don't go into education to to hurt students. There might be some few bad actors out there, but districts are not out to harm kids, and so it became a very difficult legal standard to get past. The case went before the Supreme Court, and I will say that it was, very experienced counsel was arguing the case. However, where the school district made, I think, a miscalculated judgment. And hey, listen, we as lawyers always do strategies, right? We always try different approaches, and so this is kind of one of those ones where I think they had a case where for school districts they were trying to get a heightened standard. But at oral argument, they actually were trying to get all disability statutes to have a higher standard, whereas other disability statutes and disability-based claims have that lower standard of deliberate indifference. So they kind of went to try to heighten it for everybody. And I think, unfortunately, that was kind of like they went for the far field, the home run, and ended up striking out, which is, again, good for kids with disabilities because it means that now for everybody in the country, not just the Third Circuit and the other circuits, but it is deliberate indifference. Again, that they knew about something, they had the power to change it, and they failed to do so. Now, what I think is important to that situation is that the facts of that case, and this is where, again, just understanding the implications of what that actually decides. That does not mean that the student in that case has won. What that student has won is the ability to have their case heard and that be the legal standard. Whether or not the actions in that court case of not providing education, because I've had a tremendous amount of phone calls of kids who've not received FAPE and parents thinking because of that case that that automatically leads to damages, which is not necessarily the case. But what it allows for is that the actions of the court cases that are going to come before it for damages to have that lower level of standard so that we're not, and it's consistent. It's not just in the state of, Pennsylvania or Delaware. It is also in Minnesota. I just think kind of long term, we're going to see more of that. And the reason for that, and I'm going to go into it a little bit further on when I get down in my presentation, but part of what has kept a lot of cases out of the Supreme Court and what has to the extent possible, had a level of consistency in the interpretation of IDE has been the Department of Education issuing guidance, and dear colleague leaders, and different ways that we can look to and courts can look to say, how do we interpret that provision? And again, when we get to that circumstance of, let me explain, because I think it's important, because you're like, well, that's easy. I mean, we have the law, right? Well, not necessarily. So it is a situation where and I'll give you a real life example. So reevaluations should occur on a periodic basis. That's what the law says. That's what IDEA says. What is a periodic basis? That is interpreted differently, and there are different state laws that involved. In the state of Pennsylvania, there is a state statute that says that is to occur every 3 years, 2 years for students identified of ID, but it has to occur at least on a triennial level. In the state of Delaware, there is no provision regarding that. So Delaware takes the position that there is no timeline. They could do it 4 years, 5 years, every year. There is no situation where there is a timeline in regards to reevaluations. So unfortunately, that will lead to, although there is a law, right? That interpretation of that is different. Now, historically, you might have guidance then come out. So a dear colleague letter would go up and say, hey, Department of Ed, how often should we, to meet the standard of periodic reevaluations, how often do states need to be, or districts need to be reevaluating kids? And they may issue guidance, which is every 3 years, every 4 years, every, whatever the guidance is. And then states can go, oh, okay, well, the Department of Ed says that's how we need to do it. So that is kind of where, though, given where we're at with layoffs in different areas, and we are not getting the level of guidance that we have historically. But I'm going to again get to that a little bit more when I talk about what's occurring at OCR. There are a couple other bubbling court cases out there that I just want to bring your attention to. One of them is a concerning one, just because, again, it's something that has happened in history and could happen again. So, and is occurring again. So, JN versus the Oregon Department of Education. That involved a court case where there was, for reasons I won't get into, students shortened school days for students with disabilities, and it was systemic. It wasn't just like one student had shortened school days, it was systemic. And whether or not a child was entitled to a full day of education, the court allowed that court case. There was motions to dismiss. It is going to be heard. Why is that important? You're like, okay, well, that's doesn't seem like that's that big a deal. There is a case out of Hawaii from many years ago where, because of the economics that were occurring in the state of Hawaii, they had to shorten school days for everybody. And for kids with disabilities, the court there held, and again, this isn't a Supreme Court decision, but that federal court held that it was not discriminatory and it didn't violate IDEA if, in fact, it was done for all kids. So we are heading into, in the state of Pennsylvania, there was a district who was going to have to shut down due to budgetary issues, because we weren't having a state budget passed, of how and what legal entitlements that will give to kids with disabilities if, in fact, districts are shutting down for budgetary reasons. Because I will just say, I am a true believer in public education, and I actually sit on my local school board. And, take out, what is occurring at the Department of Ed, post-COVID, funding for districts, whether or not the funding streams are different, it's difficult. And most districts in the nation are underfunded. They're just underfunded for a variety of reasons. And there isn't one singular reason. So we are heading into times where, if districts are going to shorten school days or are shortening school days, as if it is a situation where it is non-discriminatory, what legal entitlements kids in special education will have. If they're just doing it for kids with disabilities, I think there's a better argument that appears what's occurring in JN. But unfortunately, that is one of those things of what happens. And I think what is going to happen is there's going to be districts who are going to look for the low-hanging fruit of where to cut. And If you look at the budgets of most school districts, you will see that the number one cost is personnel, and that's people. That is the number one cost. Absent that, the second most cost usually is um, special education. And so when you have school boards or management of school districts looking to where to cut the budget, a lot of times you're going to see it in those two realms, unfortunately. So it is certainly to be mindful of that possibility that districts may look to shorten days nationwide. It has happened historically, it is happening again, and it's something to be mindful of. There is another court case out there that I found interesting as a practitioner in this. I think parents will find this interesting, and it's something that is a struggle, I think, for a lot of people. Sandra S. versus the Upper Darby School District. So this is a case where parents have under IDEA and FERPA their right to their children's educational records. And so when they go and ask for them, and I will say 99% of my clients, I have either asked for them or I asked for them. I'm trying to think of a case where I haven't. I'm sure it has happened in, over 20 some years, but I cannot think of it. We want the complete educational file. And there have been times that I have not been able to get that. And by that I mean I haven't gotten anything, or they send me stuff and it's missing nursing records or counseling records or the progress monitoring records or the emails. So this case originated kind of as a standalone. Do they have a right to those records? Is that in itself a court case? I actually did file a due process claim many years ago against a district for failure to provide the records. The court found it does not necessarily give right to a standalone court case. Now, I did not look at the pleadings. I think if you're going to have a situation that you need to pursue a claim, I think it needs to be predicated on the parent's ability to meaningfully participate. There does, and there is, and I think we see it in a variety of court cases in a variety of different manners, this new push for parental rights, right? And it occurs in a lot of realms. And it is getting a lot of positive court feedback. And so, while the right to records in this court case is not necessarily a standalone, I think it needs to be tied to, if we're not getting records, kind of this ability for parents to meaningfully participate. If they do not have access to the same level of information that the districts do, does that impede their right to meaningfully participate in education? And parse it as part of that, because that type of lawsuit seems to have a better reception in the court systems than maybe just the whole we didn't get all the records. But again, that is just happening in Pennsylvania. That is not something, or I should say, the Third Circuit. That isn't necessarily a nationwide situation, but it is something to be mindful of. Okay. So the next kind of parts, that's kind of like the legal updates of what's been going on in the state of education law. Just FYI, I did do a search. There is a lot of parental rights and other lawsuits pending, not pending, asking to be heard by the Supreme Court, but there is no other pending petition that the court has been asked to potentially hear in regards to necessarily special education. As I said, we don't get a lot of special education Supreme Court cases, so when we do, I think we practitioners are excited and equally holding our breath because we never know what's going to be found. But right now, there's nothing out there that's going on. All right, so what has been occurring in OCR? So between March 11th and June 25th, and I'm pulling this from different articles and litigation that's occurred, ODR dismissed, OCR, sorry, not ODR. OCR dismissed 3,424 complaints out of 4,833, which is roughly a 70% dismissal rate. Now, I'll be candid with you. I could not find, and I did search for what the stats were previous to that. So, but the allegation was that this was it was a huge, large increase. During that same time period, only 309 complaints for investigation were launched, and 26 were directed investigations. And they resolved 96 complaints finding either insufficient evidence, and 290 were resolved under apparently a voluntary agreement, which is again, something where the parties kind of agree how it's going to occur. So when I started giving these talks back in probably March of this year, I got, hey, and I liked it and I appreciate it. I was talking about the fact of they had current layoffs in OCR, the implications of that, and a lot of the questions I got back, which were fair questions, which is, well, just because we're moving it to HSA or just because they have staff, that doesn't mean it's going to ultimately impact. Unfortunately, and my statement was if there is no one to resolve the complaints, it will absolutely impact. And I think that's bluntly what we're seeing is that the Office of Civil Rights, which one of the nice things about it is it did not require a lawyer to be involved. Parents didn't have to get lawyers. They could pursue those claims with OCR, provide the evidence. And they were really thoroughly investigated. They had really smart, capable staff there. And unfortunately, there has also been a tremendous amount of just closures. I mean, they have closed all the offices in Philadelphia, New York, Chicago, San Francisco, Dallas, Boston, and Cleveland. There's only 5 offices left now, regional offices. So we are in a situation where OCR is not something that is as effective or as involved, just again, bluntly based upon the stats that they were historically. And I think that was one of the talks that Monica had talked about, which is, well, if that's the case, then what do we do now? Where do parents go? And I kind of was thinking about that this morning, and in some respects, we're kind of in an educational pandemic. And by that I mean is I remember saying to my husband during the COVID pandemic, I was like, it was early, early mid-March, or no, I guess late March after the shutdown. I was like, I just can't wait for this to be over with and I'll go back to normal. We'll all be fine. We'll all go back to normal. And he goes, my husband loves history. He goes, we're never going back to normal. And I was like, what do you mean? Of course we're gonna go back to normal. He's like, Heidi, he goes, I don't think if you understand history, how pandemics influence societies. He's like, it doesn't go back to normal, it changes it. And he told me the story of um he's also from Easton, Pennsylvania, and apparently which is home of the Dixie Cup, which apparently is a result of the Spanish flu pandemic. And the reason for that is previous to that, how people drank at work sites or drank, just out in public was you get a big bucket and a ladle and you drink all of the same thing. Well, when the Spanish flu influenza came, they created the Dixie Cup, and that has kind of, although we don't think of it as an alternate society, it did alter how, people even, drank water at work sites. So the reality is we are in a situation where the Department of Ed is undergoing fundamental changes. Um, it is not going to be it is not going to be a situation where like, well, if we just vote a new admin in next time it'll completely go back to the way it was. It's not going to go back to the way it is. It's just we are kind of fundamentally altering it. Some things may go back, some things may get better, some things may get worse. We don't know, but what we do know is we're probably not going back. So what do we do? One of the things I will say is it is incredibly important that people start advocating at the lower levels because the national level is not going to be making the level of changes right now that need to occur. And you're going to say, well, what do you mean by that? Like, how local are we talking? And it takes a variety of different formats, okay? So, blessing or curse, as I said, I work for school board. So, I have had a little bit of a better insight into kind of local politics than I had prior to running for school board. And I will say to you is assuming knowledge on behalf of leadership, either on your school board, your state reps, your state senators, um, there is no knowledge. And I don't say that unkindly or meanly or self-deprecatingly, but when I tell you as a school board member, I know special education. The level of information that is given to even school board members about what is occurring in terms of problems in special education or issues or how things are managed, that does not occur. That is handled at an administrative level. The idea that your state senator or your state rep knows that your district is not evaluating kids, or the state has a new policy where they're doing something wacky with kids with special education, they do not know about it. They just don't. And as much as it seems kind of weird to say, call your representative, and I know someone who has called my, U.S. senator or U.S. rep, the level of feedback sometimes you get is not terribly feeling responsive, right? But if you get down to the local levels of your state reps and your US reps, they have offices in their group. And I will tell you, as someone who my son actually interned and worked closely with a Pennsylvania state rep, they people walk in, and I will tell you, the people who walk in and look to me and bring the things, they are addressed and they are raised to the first time at a state level. And I will just say this: state reps and state senators need people, they need real life cases to be able to advocate it on a national. They need a face. They need a problem that then they can bring to, the state legislator to say, Mary and Joseph in my district, recently experienced this fact, and this is impacting all the kids in the state of Pennsylvania. So again, the advocacy, I'm not suggesting shouldn't occur on a national level, but what does absolutely need to be occurring is it needs to be happening on a local level. If it means pushing back for your own kid or as a group of parents at the district to effectuate change of policies, you need to do that. Part of, we look at history, and again, my husband's a much better study of it than I am. Banding together in a group is much more effective. So starting parental advocacy groups at your district, creating situations where you're communicating things to the school board, where you're communicating things to the state rep, and do it in person. I mean, as I said, I can count on one hand almost every meeting how many parents show up or community members. That happens at all local levels, right? The county commissioners, the townships. Not a lot of people are involved. We need to be involved, and that in our voices to be heard and speak at the podium. That is truly much more effective than I think I felt previous to being involved. And as much as maybe you don't see the immediate change, I can tell you, you hear it once, you hear it again from someone else, it does effectuate change. So unfortunately, the disability-based, advocacy groups, we need to start arguing at local and state levels and pushing back. And I'll give you another example of why that's what happens when you don't give a pushback. So back in 2016, we were getting a lot of cases at my old firm, calls from the state of Delaware. And in the state of Delaware, was really no one actively in the state representing parents for special education services. And it's the Third Circuit. And so we had hired a Delaware attorney and we went down there. And I opened the office, and I remember sitting in one of the first meetings down there, and they were very, very proud of now this is 2016, their DAP program, which is the Delaware Autism Program. And I was like, what is the DAP program? And they're like, so any student that is identified with autism, they all send to these DAP schools. So they're completely segregated, but in terms of, they didn't use the term, so they're together, and we can put all the supports and services in one building. And I was like, that's not inclusive. That's not LRE. And it was so rigid at that time that I had a student who was very bright, who wanted to take AP courses, who wanted to be involved at his local high school. And the local high school said, "Oh, he can't come here if he has the autism diagnosis." And I said, "But he just needs some social skills." And I'm sitting in this large high school where we want the kid to go to, And they're like, we don't have that here. And I said, in this entire building, you're telling me you don't have 5 or 6 kids that you could create that doesn't need social skills that you couldn't create a group around? We did get the kid transferred, but the problem is systems left unchecked and unpushed back on create unfortunate situations that don't necessarily lead to good places for kids with disabilities. And there is a lot of disparity in our systems. If you look at the stats, Pennsylvania may have 800 due process requests, where another state has one or two. So that can happen at a situation where it is a very disparate situation. But systems that are pushed back on create much more educated decision makers. And you're going to say, what do you mean by that? So I have had to try cases in different jurisdictions. How cases are tried are very different. For example, in the state of Pennsylvania, we have a hearing officer corps completely dedicated to hearing officers. Same thing with Washington, D.C., same thing with New York State. But in the state of Maryland, they don't. They basically use administrative law judges who hear a variety of different workmen's comp. And if you go down there, God bless them, the administrative law judges show up with the book that they're given by their state to tell them what the laws are. That's how they understand it. If they hear more cases, you're going to get much more educated decision makers. And again, for parents with kids with disabilities, it doesn't necessarily require a lawyer to handle it. But pushing back, advocating for your child at the state level, at the local levels is much more important. Um, Two other topics that I just wanted to talk about because I just think it is just something to be mindful of before, I'm willing to answer any questions, and it doesn't have to be on topic. It can be on anything else that people want to, discuss. But there was just occurred, I think it was in November, transfers. Right now, there was a lot of agencies that were transferred in terms of Department of Education through different, and they're called IAAs, which are interagency agreements, transferring the oversight from the Department of Ed to, different ones, anywhere from the Department of Labor, to HHS, to DOI, the Department of Interior. Right now, though, OSEP and OSERS are still within the Department of Ed. My understanding, and we did all think that that was being transferred out, but they were not. Now, whether or not I think they're still slated to, but that has not occurred. The other thing too, just to update, is they did hire back all but one of the OSEP members that were, or OSERS members that were furloughed or let go during the closures, but they are slated to be further reduced in staffing. I think we're going to get better pictures of exactly what's going to happen to OSEP probably by March of this school year, or March of the school year, of how deep those reductions are going to go. But again, we're not, they haven't been to the extent right now, but what it will look like, we'll have a much better, clearer picture in March again of 2025. The other thing I want to talk about, and I'm sure this is going to be kind of tangential, but it's something that in my practice I think is really important for the LDA, is the English language learners. And again, those are students who English is their second language and they struggle with it. Unfortunately, one of the things I will say is for ELL kids, part of the difficulty is most districts have difficulty identifying those kids who have authentic learning disabilities when they're learning English, like reading disabilities. There was guidance that was very clear about ELL's entitlement and exactly kind of laying out the framework of exactly what districts needed to do to meet the legal federal requirements for ELL students. That guidance was removed and is now considered historical. So, and they've not issued new guidance. So, what right now districts need to do to provide for students with ELL needs is unknown. So, unfortunately, I'm sure some school districts will continue under the historical guidance, and there are other districts who say, well, Now the Department of Ed says that historical guidance is just historical and we don't necessarily need to follow it. So that could open up a brand new set of decision making. And I will say that that goes back to, and again, just an important historical note, the back of something that happened. It was either 2024 or 2023, but there was a court case that came through the Supreme Court that basically, kind of talked about the fact that courts really need to decide what the level of decision-making process is in terms of the interpretation of the federal court statutes, meaning that where the Department of Ed or the, whatever department it was, Department of Labor, Department of Interior, their guidance didn't carry as much weight as it did historically. So there had already previous to 2025 been a pushback on reducing federal guidance power. But now that guidance has been removed for ELL students. So again, absent we getting some court decisions, and ultimately there's going to be a decision where it'll be the law of your land, meaning in terms of your circuit. When it will ever be decided the law of the land, which is a Supreme Court decision, that is all something that is we're going to all be figuring out together, especially as we kind of sift through. But I will say, given the fact that there is less reliance on department guidance and there is going to be more reliance based upon what the Supreme Court said on what courts say, and hey, no two courts disagree all the time. I do think we are going to be, I'm going to use my little power of ESP, not necessarily right now, but I think 5 to 10 years from now, you're going to see a lot more Supreme Court decisions in terms of um, that. Because again, without the federal guidance, the federal weight that that guidance historically held, it's going to probably lead to more court cases that where there's going to be a lot of discrepancies between the different circuits to have to be decided by the judiciary. So that's kind of the stuff I had on my list to talk about. Monica, was there anything else that you had thought of that I missed or I didn't talk about?
No, I was actually thinking, you said there's not much to talk about, but I think you did a pretty good job because that was a lot. Um, we do have one question right now in the
Sure.
Q&A. I don't know if you can pull that up. It's kind of a long one, but I can read it. That about Hawaii has Board of Compliance, but they are not transparent or working in the interest of students. Where can parents and teachers go to correct this? And then Stephanie also notes that the Hawaii Attorney General is the Attorney General for, or is the attorney for the Hawaii Department of Education. The State Board of Education is appointed by the governor and no longer elected, and there is no teacher union rep.
Okay, so let me paraphrase what I think I heard you say because I'm having difficulty pulling down, which is if you're dealing with a school board or board of education that, and again, it's very different in every state, right? So in Virginia, your board of education, your school board is countywide. And so and again, just think of where you're at. Like if you had one ruling body for an entire county, they're going to be kind of much more removed than your neighbor who's sitting on your school board of where you're, each class is about 700 kids in it, right? So is my understanding that the kind of so if you have kind of a board of education that's not very transparent, what do you do? Is that the kind of question?
I think that is the question. Yeah, Stephanie, if you want to either clarify in the chat, or I think Stephanie is feeling like she doesn't really know where there's recourse if there's concerns.
So again, you kind of, I've always talked about, especially when I talk to parents, kind of this stepladder chain of command you want to go up to, right? Um, in terms of the Board of Education, I will just tell you this. And again, I don't know how you're communicating with the Board of Education. As someone who sits on a board and who's around a lot of other board members, I can tell you the least effective tactic is email. You may write this completely beautiful crafted email. I read it, but I can tell you when I'm sitting around the table with other board members, I'm like, "Did you see that email from the parent?" And they're like, "No, I didn't look at it. I just figured admin was handling it." What is highly effective is speaking at public meetings. You are then in their face, being able to tell them directly exactly what is occurring. Now, that may not mean that you get a response, right? And you may not get a response at the table. And it may mean, in some respects, you feel like nothing's happened. And to a certain extent, one of two things is that is either true, that they just kind of listen to you, nod their head, and they've gone back and they're going, so, where are we going out for coffee afterwards? Or it could be that that's causing conversations that you may not be aware of. Okay. So again, listen, we have to kind of look at what strategies are effective, right? And where do we see strategies being highly effective? Marketing. And I hate to say it, but marketing talks about repeated exposures, right? If you think you go in one and done, they just show you an ad one time and you're like, I didn't pay attention. I think it's a rule of seven or something like that. So to me, and the fact you don't go away. I mean, that to me is one of the things that is very effective tactic. And I've utilized it myself because I I talk a lot. And I noticed that when I started as a child, even if I just didn't shut up enough to my parents to get me to shut up, sometimes I would get what I wanted. So that effective nature of continue to speak consistently, because the desire is going to be for you to be quiet. That is going to be desired, and they're going to have to find some way to make you quiet. But I will also say getting other people to attend, and that's part of that community-based action that you need to start building. The great thing about disabilities is, and there's a lot of great things actually, but it cuts across every boundary, right? There is no, it only affects certain genders, it only affects certain races, it only affects certain economic classes, it only affects certain political parties. It truly is an area where we can community build with the same goal in mind of trying to get what is right and what is entitled for our students. Because I will say this, as someone who has practiced this area, and I'm sure a lot of other people on this call can say, when education is done right and these services are given to kids in line with what is it intended, it changes children's outcomes in life, fundamentally alters their capacity of what they're able to achieve and the opportunities that they will have in their life. Education done wrong alters a child's path in life. It alters the opportunities they can have. It alters what they're able to achieve and obtain. And so that is what we all should be fighting for, is the equal opportunity for our kids to be able to obtain what they can based upon their ability obtain. And
Okay.
the other thing too is if it does start with the Board of Ed, go to your local state senator, go to your local rep, be a nudge in their ear, show up to their offices. I mean, again, you'd be surprised. You get in that state rep's office, they take you a lot more seriously. They want to please you. It just getting active and getting in person with people is really important.
Okay, great. We have a question from Karen. Is there recent guidance on defining LRE in terms of benefit to the students for being in a specific learning environment?
There's no national guidance right now. We have gotten no real new guidance on any type of special education. Right now, they have not issued the new 504 regs in terms that was really undertaken during the last administration. The only new guidance we got was the removal of ELL guidance.
Okay. All right. Harold asks, in the spring, Ed's OCR said that all investigations alleging disability discrimination that also alleged other forms of discrimination, for example, race and disability, would be placed on hold. Do you know if this is still true?
I don't know if that, I'm assuming, I've not heard a shift to that guidance, but what I have seen is in terms of since the spring, a lot of dismissals. And again, that was coming from the pleadings to maintain the employment statuses of those employees. I think it came from their union rep about that. So yeah, it is a situation. I've not heard there be any change to the guidance, but at the same token, what it is clear is that they're moving towards a tremendous amount of dismissals.
Okay, I don't see any more questions right now. We'll give it a few more minutes. I do want to share that when we send out the link to the recording, we are also going to send out a letter template that you could use to contact your state representatives. And this is the 50th year anniversary of IDEA. So if you or your family member has benefited from IDEA, you might want to put some examples of that into that letter that you could then share. Because as Heidi has said, we assume that people know a lot about the laws that they're being elected to help to enforce and create, but that's not always the case. So it's really important for our representatives to hear from us either in person or in a letter. And as Heidi noted, we can send emails, but they might not be paid as much attention to as a more personal contact.
And I will also make a plug, and as what's that slogan goes, and I'm not paid for this is an unpaid advertisement. Um, I do really encourage parents, and anybody who is involved in this field to go to conferences like the LDA conference. And the reason for that, and you saw one of the highlighted situations, is advocacy. Learning to be an effective advocate for kids with disabilities is really hard. And I say that as someone who had to learn how to be an effective advocate for kids with disabilities because I became a lawyer, right? They don't teach this in law school. They do not they don't teach strategy in law school. They don't teach advocacy to a sense of like advocating for students with disabilities. You get the learns of the law and how to prep a court case. And so I, in my very infancy of being 25 and sitting at IEP team tables, it was not very effective, right? Because the districts would start saying, and I will say this, there is a level of authority that districts present with, right? And there are times that what they are telling you is just absolutely incorrect, but they say it with such authority, it will make you question yourselves. So I remember being very shut down very early on just because of my lack of information. And then about like so many years into it, I was like, wait, that's not right. And being able to push back is based upon knowledge, right? The more knowledge you have, not only of kind of what your rights are, but how to effectively state them in a way. So again, like if you want to advocate, there's always, what is your goal? And that's kind of when I talk to parents is and I say, listen, I want to know what your goal is because then we can develop the strategy about how to get there. So I have parents who will say to me, I'll give you an example. I want daily communication because I don't trust what they're doing. Well, do you think that's effective if I go to an IP team table and say, I want daily communication because my class doesn't trust what you're doing? They're going to say, well, they need to trust what we're doing. We're doing all that, you're never going to get daily communication that way. But how do we advocate for it? We advocate saying that my parents want to be equal partners and be able to reinforce what the child is learning at home. So we would like daily communication so that we can positively reinforce other behaviors or work on the same skill sets or communicate with the tutor. We do it in that form. That gets a much more positive result. So you need to learn what your rights are, but also how to effectively advocate for them. And again, the way to do that is to learn from others who have a lot more experience. I mean, I will say this, Monica's always very kind. When she first met me was when I was sitting across the table, cross-examining her for the first time. That was our first introduction. And I was very young in my career. And I tried to learn as much school psychology to cross-examine the school psychologist as I could, and she schooled me. But you know what happened? I learned better. The more you learn, I became a better advocate because I learned from people who know more than me. So as much as you can attend these conferences, it is really imperative to do so. Just because, again, we are kind of heading into a new realm where our advocacy on an individual level is going to be very critical to our own kids, but also our community.
Okay, we have two more questions.
Oh,
Joanna,
good.
Joanna asked if you could address what is going on at DOJ Office of Civil Rights and what it oversees, testing entities. I'm not 100% sure I think you did kind of address the fact that they've dismissed a lot of the complaints.
Yeah, they've closed the majority of offices in OCR that see the complaints. I,
Mhm.
I have not heard that they've transferred those over to the DOJ, and I can't imagine they transferred over to the DOJ. And the reason for that is because those are basically the criminal attorneys. They're not, there is some civil divisions, I guess, but like I have not heard them being involved in that at this juncture. Now, whether or not that happens, that theoretically could happen, but that's not my. Right now, OCR is still in a situation where it's just been cut significantly and the complaints have been dismissed.
Okay. And Benita asked, oh, okay, wait a minute. Joanna had a follow-up. The DOJ was behind the consent decree with the LSAT. So I guess she's asking if you've heard anything about DOJ OCR involvement with testing entities.
I, I'll be 100% with you. No, I don't really deal with I deal with like birth to 21 in terms of like school age covering ID in section 504. As I always say, I'll know what I know and I know what I don't know. And if you're talking about like in terms of post-secondary, I am outside my bailiwick on that one.
Okay. And then Benita has a question. How is it that you got into this type of advocacy and this type of law?
Oh, wow, that's an interesting question. So without going into too much detail, I grew up with a sister with significant disabilities. And I always thought and felt that the district in her circumstance really failed her. And I still believe that to this day for a variety of reasons. I mean, she's kind of what happened to her in the educational system is kind of a poster child of what should never happen to any student on a variety of fronts. To just without going too much into it, there was actually even incident, and this is again, we're talking the 80s here, but there was an incident at the school system that the local newspapers picked up in regards to her, and the principal gave a full detailed interview to the newspaper, just detailing all information that should have and today would have been not disclosed. So
Mhm.
I really had a passion for helping students with disabilities because I'm going to be again very, very honest and direct. Her outcome isn't great. She is still, on full disability and severely impacted. And so my goal was always to say, I can't necessarily change all outcomes, but I can try to make things better for other people. And that's kind of what prompted me to get into this field and start this. But I will say that even having that background, I did not know a lot coming out of law school. I had to learn a lot. Having a passion does not necessarily mean being effective.
Okay, Steph, we'll have one last question. Stephanie, it's kind of a individual question, but it is
Sure.
a question that I have heard from other people. So we'll throw it out there and see if you have any advice. So Stephanie's question is about trying to help a student who has been rejected by numerous private schools for admission because of a disciplinary history.
Yep.
Is there any recourse for the family?
Yes. Okay. So I can tell you what I would do. And again, this is the state of Pennsylvania. Um, One of the things that we can do is because ID is an equitable statute. And absent there being state law that prohibits this, and there is no state law in the state of Pennsylvania, we can have records redacted or amended. So there are times, for example, if I have a student has been expelled from a school system where I think it was based upon a manifestation of a child's disability, we have had the districts remove that expulsion from the records. So there are things that can be done to, on an equitable way, to remove things if they are due to a child's disability to make sure that the records accurately reflect. I mean, listen, if a child has a disability and it has impacted them, even when you apply to college, if they give you a little format where you can explain like something medical that's happened to you. Because if, for example, a child failed 3 courses because they had a concussion, right, or had to do credit recovery, not because they failed the course because they weren't knowledgeable about it. We would never think, oh, that's horrible. Like you're going to correct, like that doesn't accurately reflect. That's the whole point. If you've had a medical situation that has resulted in it, of course you give a child another opportunity to be successful. Of course you create a situation where you communicate why that happened. That should be nothing different than for a student with a disability who has a disciplinary history because of the fact that their disability was unremediated or unaddressed appropriately.
Okay. All right. Well, thank you, Heidi, for a great webinar. I do want to urge people, if you're not already a member, it's only $55 to become a member of LDA, and we have a whole webinar library where you can see Heidi's earlier webinars and webinars on many other topics related to advocacy and learning disabilities. And finally, one more plug for our conference in February. It's in St. Louis, February 16th to the 18th. And we will have a number of sessions on advocacy, on best practice for students with who are multilingual students with disabilities, and many other topics. So I hope to see some of you there. And thank you, Heidi, and thanks for everyone's attendance today.
There was a question about how to join. So if you are looking to join LDA, you can do so through our website. It's ldaamerica.org.
Thanks.
Oh, and Lauren posted the link in the chat. So thank you, Lauren.
All right. Thank you,
We'll
everyone.
include that. Yep, we'll include that link in our email as well. You can expect to have the email within 48 hours, so keep an eye out for that.
Thanks.